Hi everyone, welcome to my YouTube channel. This is Nilay Kumar and we're going to continue with our Constitution Law series. Today we're going to start with Article 12 of the Constitution of India. So let's read what Article 12 tells us about. The header of the Article 12 is definition. Kindly remember that this is Article 12 is contained in Part 3 of the Constitution of India. In this part, unless the context otherwise requires, the state includes the government and the Parliament of India, the government and the Parliament of India, the government and the legislature of each of the states, all local or other authorities. Right? So, let us understand what Article 12 tells us about. Let us break it into elements. The first thing that you can observe here is they are specifically mentioned in this part. Now, what does this actually mean in this part? What is the relevance of this? This means that the definition of state, which is given in Article 12, will be applicable to only part 3 of the Constitution, right? So whatever provisions we have in the previous video we discussed, right, from Article 12 to 35, whenever the term state has been used in Articles 12 to 35, it would mean whatever is written here in Article 12, right? So this is what this tells us about. Then you have an exception here. The exception is unless the context otherwise requires. Now this means that either specifically it has been mentioned in the constitutional provision, or the context is such that this definition of state given in Article 12 can be used. So this is an exception, right? So if particularly it has been mentioned in a constitutional provision that the definition of state of Article 12 is applicable in this part or in this provision, or the context of that article is such that it appears that the definition of state in Article 12 should be applicable to that provision, then in that case Article 12 will be applicable to that provision as well, right? Now let us move on to what the term state actually means. अगर आप देखेंगे, मैंने आपको यहाँ पे अंडरलाइन करा है, यहाँ पे 4 चीज़ें. First is your Government of India and Parliament of India. I am writing it as POI. Okay. Second, you have second you have the state legislatures, right? The state legislatures and the state government, right? Third, you have local authorities, right? And last, you have other authorities. Now, if you look at the first 3 elements, that is Government of India and Parliament of India, state legislature and the state government, and local authorities, these are self-explanatory, right? In fact, the Government of India, the Parliament of India, the state government, the state legislature and local authorities, all these terms have been defined in one or the other part of the Constitution, right? However, the term other authorities hasn't been defined in any of the provisions of the Constitution or any of the statutes passed by the Parliament, right? So the question arises, what does other authorities actually mean? This is what the various high courts and the Supreme Court have done right from 1950s till 2023, interpreting the term other authorities. This is what they have done continuously. So now what we're going to do is, this entire video is all about case laws. Article 12 is full of case laws, but there are not many case laws, hardly 8 to 9 case laws. All these 8 to 9 case laws we'll be discussing in this video, and we'll try to understand what does the term other authorities actually mean. We're going to see the evolution of the interpretation of the phrase other authorities, right? So let us start with the case laws. Now the first case law that you can see is University of Madras versus Shantabai. The first institution that was brought to the notice of the courts with regards to whether it can fall under ambit of state under Article 12 was a university. In this case, the Madras University. This was the point of contention in this case. Now this is a Madras High Court judgment. Please remember this, that this is a Madras High Court judgment and not a Supreme Court judgment. The Madras High Court had observed here in this case that other authorities could only indicate other authorities of a like nature, and they had invoked the principle of adjustum generis. If you see, the principle of adjustum generis was invoked here, which mean only authorities exercising governmental or sovereign functions. It could not include persons, be it natural or juristic persons, unless it is maintained by state, right? तो यहाँ पे अगर आपको रेशियो पूछा जाए तो आप क्या बोलेंगे? यहाँ पे यूनिवर्सिटी ऑफ मद्रास वर्सेस शांताबाई में भी ये बोला गया था दैट एनी इंस्टीट्यूशन विच इज मेंटेन्ड बाय स्टेट वुड बी नोन एज other authorities, would be covered under the term other authorities in Article 12, and therefore it will be state, right? How did they come to this conclusion? By applying the principle of adjustum generis. Now what is the meaning of adjustum generis? Let us understand. Let me give an example here. I am writing car, truck, van and other vehicles, right? If you see, you can find something common in car, truck and van, that is all these vehicles, right? या all these and other इसको हम vehicles की जगह other transports कर देते हैं, ठीक है, more general word. तो कार, ट्रक और वैन ऐसे ट्रांसपोर्टेशन मीडियम हैं जो रोड पे चलते हैं, राइट? दे आर ड्रिवन ऑन रोड. तो अगर मैं अदर ट्रांसपोर्ट्स कह रहा हूं, आई एम सो सॉरी, अगर मैं अदर ट्रांसपोर्ट्स कह रहा हूं तो इसका क्या मतलब होगा? हम वैन के बाद क्या मैं इसके बाद एयरप्लेन लिख सकता हूं, या फिर इसके बाद मैं लेट्स से शिप लिख सकता हूं? द आंसर इज नो, बिकॉज अगर आप इंटरप्रिटेशन ऑफ स्टैट्यूट्स के पॉइंट ऑफ व्यू से चलेंगे तो आपको समझ में आएगा कि प्रिंसिपल ऑफ एडजस्टम जेनरिस ये बोलता है कि अगर पीछे के ये जो भी 3-4 टर्म्स है एक सेंटेंस में या एक प्रोविजन में यूज़ किए गए हैं, ठीक है, तो आगे के जो टर्म्स में अगर अदर या एटसेट्रा जैसे वर्ड्स का इस्तेमाल किया गया है तो वहाँ पे सिमिलर काइंड ऑफ वर्ड्स को ही इस्तेमाल किया जाएगा बाय लुकिंग एट द प्रीवियस यूज्ड वर्ड्स इन द प्रोविजन. तो अगर कार, ट्रक और वैन है तो मैं यहाँ पे क्या यूज़ कर सकता हूँ? ऐसे व्हीकल का नाम, ऐसे ट्रांसपोर्टेशन मीडियम का नाम जो रोड पे ड्राइव किया जाता हो, ठीक है, जैसे लॉरीज. एयरप्लेन एंड शिप ऐसे ट्रांसपोर्टेशन मीडिया हैं जो रोड पे ड्राइव नहीं किए जाते हैं. आर वी क्लियर विद दिस? सो एडजस्टम जेनरिस का प्रिंसिपल मद्रास हाई कोर्ट ने अप्लाई किया. उन्होंने क्या बोला? इफ वी गो बैक टू दिस, उन्होंने बोला गवर्नमेंट ऑफ इंडिया एंड पार्लियामेंट ऑफ इंडिया, स्टेट लेजिस्लेचर एंड गवर्नमेंट एंड लोकल अथॉरिटीज़, ये सारे के सारे एक ही जीनस को या एक ही कैटेगरी में इन्वॉल्व हैं, एंड देयरफॉर अदर अथॉरिटीज़ भी इन्हीं से रिलेटेड कुछ होगा. तो इन्होंने क्या किया? इन्होंने एक रिस्ट्रिक्टिव इंटरप्रिटेशन दिया है. मद्रास हाई कोर्ट ने इस केस में एक रिस्ट्रिक्टिव इंटरप्रिटेशन दिया और कहा कि इट वुड ओनली इंक्लूड दोज इंस्टीट्यूशंस विच आर मेंटेन्ड बाय स्टेट. उन्होंने ये समझा कि गवर्नमेंट ऑफ इंडिया गवर्नमेंट कंट्रोल करती है, पार्लियामेंट ऑफ इंडिया भी समहाउ गवर्नमेंट कंट्रोल करती है, ठीक है, तो कुछ वहाँ पे गवर्नमेंट का इन्वॉल्वमेंट है, कुछ ऐसा इन्होंने कहा. उसी के बेसिस पे इन्होंने कहा इट शुड बी मेंटेन बाय द स्टेट, ओनली देन इट वुड बी कंसिडर्ड अंडर द डेफिनेशन ऑफ आर्टिकल 12. आर वी क्लियर विद दिस? Now let's move on to the next judgment. Srimati Ujjambai versus State of Uttar Pradesh. Okay. Now the view which was taken by the Madras High Court in this previous judgment, Ujjambai versus State of UP, the court rejected this restriction to the interpretation of the word in this case other authorities right? In this case, the court rejected this restriction to the interpretation of the word other authorities given by the Madras High Court and said that the rule of adjustum generis, could not be applied to the interpretation of the expression other authorities as there is no one genus under Article 12. Right? So they have overruled what was held in Shantabai versus Uttar Pradesh. Okay. So they have overruled it. They have said that the terms, the four terms used, they do not belong to any particular one genus. They are of different categories, and therefore this restrictive interpretation that only those institutions which are maintained by state cannot be considered to be correct. Okay. Now let's move on to the next case. This is Rajasthan State Electricity Board versus Mohanlal. Now the next institution that came to be questioned before the courts was a state electricity board and whether it could be included within the definition of Article 12. In this case, it is the Rajasthan State Electricity Board. Right? The Supreme Court rejected the principle of adjustum generis here also and overturned some previous decisions of the High Courts. One of the decisions was Madras High Court, and there were some other decisions of other High Courts as well. So they have rejected the principle of adjustum generis, and they have also overturned some of the decisions of the various High Courts, and they have referred to the dictionary meaning of the term authority. तो अदर अथॉरिटीज में अथॉरिटी टर्म जो यूज़ किया गया है, द सुप्रीम कोर्ट हैज़ रेफर्ड दिस टर्म टू द डिक्शनरी एंड it said that the expression other authorities is wide enough to include within it every authority created by a statute and functioning within the territory of India or under the control of India. Now this is pretty important. Created by a statute, right? This is the ratio of the judgment. Ratio of the judgment का मतलब होता है मेन ऑपरेटिव पार्ट क्या है, ठीक है, एक्चुअल बात क्या की गई है किसी जजमेंट पे, उसको हम रेशियो ऑफ द जजमेंट बोलते हैं. तो राजस्थान स्टेट इलेक्ट्रिसिटी बोर्ड वर्सेस मोहनलाल का केस जो है, इसका रेशियो क्या है जजमेंट का, दैट द सुप्रीम कोर्ट सेड दैट एनी अथॉरिटी विच इज क्रिएटेड बाय अ स्टैट्यूट एंड फंक्शनिंग विद इन द टेरिटरी ऑफ इंडिया और अंडर द कंट्रोल ऑफ द गवर्नमेंट ऑफ इंडिया विल बी इंक्लूडेड अंडर द डेफिनेशन ऑफ स्टेट अंडर आर्टिकल 12 of the constitution. Right? Now there is one interesting fact that I would like to share with you all here. Justice J.C. Shah, he gave a concurrent opinion. Now what is concurrent opinion? This is very important for you to understand. The concurrent opinion का मतलब होता है, मान लो एक 3 जज बेंच है, उसमें यूनानिमस जजमेंट आ रहा है. मतलब यूनानिमस जजमेंट का मतलब क्या, तीनों के तीनों जजेस ने सेम रेशियो सेम डिसीजन पे अराइव किया है, ठीक है. नाउ दिस इज द डिसीजन, देयर आर 3 जजेस, ठीक है, देर आर 3 जजेस. नाउ या नहीं, इसको छोड़ो, आप देखो डिसीजन है, देर आर 3 जजेस. 2 ऑफ द जजेस हैव रीच्ड दिस डिसीजन ऑन द सेम रीजनिंग, राइट, whereas one of the judges has reached the same decision but with a different reasoning. So basically what I am trying to tell you here is, whenever you want to reach a destination, there are multiple ways you can reach that destination. आप किसी पहाड़ पे किसी वेकेशन पे जा रहे हो, जाने के काफ़ी रास्ते हो सकते हैं, 2-3 रास्ते हो सकते हैं. इट्स अप टू यू कि आप उस डेस्टिनेशन को रीच करने के लिए कौन सा रास्ता अपनाते हो, ठीक है. दिस इज व्हाट आई कॉल एज concurrent opinion, not me, this is what we call as concurrent opinion. तो डिसीजन सेम होता है, जो कंक्लूजन होता है, जो रेशियो होता है वो सेम होता है, बट रीजनिंग डिफरेंट होती है कॉन्करिंग ओपिनियन में, ठीक है, कॉन्करेंट ओपिनियन में. तो जस्टिस जेसी शाह ने अग्री किया था दैट एनी इंस्टीट्यूशन क्रिएटेड बाय अ स्टैट्यूट विल बी स्टेट अंडर आर्टिकल 12, बट ही गेव अ डिफरेंट रीजनिंग. लेट अस सी व्हाट ही हैज सेड. सो according to him, Article 12 must be interpreted in the context of Part 3, which guaranteed that the fundamental individual rights would not be encroached upon. This is what the guarantee of fundamental rights in Part 3 is. We are going to study this in Article 13 now, okay, in the next video. He gave 2 lines of approach for interpretation. So he is talking about 2 approaches of interpretation here. One is the legal approach and the other is the functional approach. ठीक है, लीगल अप्रोच में बेसिकली आप क्या करते हो, आप ये देखते हो दैट द इंस्टीट्यूशन विच इज इन क्वेश्चन whether it has some governmental control in any form or not. That is what you see in the legal interpretation, right? And the functional approach जो है, जिसमें functional approach आपको देखना है कि जो functions perform किए जा रहे हैं the institution, जो question में जो institution है उससे जो functions approach perform किए जा रहे हैं, what kind of function are they? इन दोनों चीज़ों को अगर आप जज करते हो, इसके बेसिस पे ही आप बता सकते हो whether an institution is state or not under Article 12. This is what he meant to say here. Clear? Let us now move on to next judgment, that is Sukhdev versus Bhagat Ram. Now, Sukhdev versus Bhagat Ram में भी एक concurrent opinion था just given by Justice Matthews. Now, this is an interesting fact that I'm telling you. Justice Matthews is often called crusader of Article 12, right? Crusader of Article 12. He talks about a welfare state and talks about whether that body can be called as an instrumentality or agency of the state that has been set up to take care of the welfare function of the state. So here the test that we're going to talk about is whether the institution in question is an instrumentality or agency of the state or not. That is the question here. You can see, right? That is the question here. Instrumentality or agency of state, right? Now, two conditions were laid down. It should be formed under a statute and it should have the power to make its own rule, right? It should have the power to make its own rule. In both these cases, they would fall within the ambit of the word state mentioned in Article 12. Okay? On the basis of this test, तो यहाँ पे जो bodies question में थी, वो थी LIC, that is Life Insurance Corporation, ONGC, that is Oil and Natural Gas Corporation, and IFC, that is Industrial Finance Corporation. इन तीनों institutions पे ये two pointer test लगाया गया, I'm so sorry, 2-pointer test लगाया गया, and it was found that they were state under Article 12. Next, we have one of the very most important and one of the very famous judgments, R.D. Shetty versus International Airport Authority of India, right? Here the question is whether an airport authority can be considered as state or not, right? In this case, tenders had been invited for the setting up of one restaurant and 2 snack bars at the airport of Bombay. Fact समझ लो तो आपको थोड़ा सा क्लियर हो जाएगा कि हम ये क्वेश्चन ही क्यों पूछ रहे हैं, right? Tenders were invited for setting up of restaurant and 2 snack bars. 2 specific conditions had been laid down that only second-class hoteliers could apply for the tender, and secondly that these second-class hoteliers must have at least 5 years of experience in that business. ये condition लगाई गई 2. It was in this case that the Supreme Court laid down the 5-pointer test to decide whether the body can be called as an instrumentality of the state or not, right? तो ये आपको यहाँ पे जो देखना है, फैक्ट समझ में आ गए होंगे आपके, ये कंडीशंस लगाई गई थी, बट हुआ क्या, फिर इन्होंने एक डिसीजन लिया, किसी का टेंडर, एक वन ऑफ द जो पेटिशनर्स था आर.डी. शेट्टी, उसका इन्होंने क्या नाम है, टेंडर इन्होंने रिमूव कर दिया, इनका टेंडर एक्सेप्ट नहीं किया, एंड दे डिड नॉट गिव एनी वैलिड रीजन फॉर इट. नाउ R.D. शेट्टी took this to the court and said that my tender was rejected arbitrarily. So the question first was, क्या वो एयरपोर्ट अथॉरिटी स्टेट होगा कि नहीं होगा? तभी आप आर्बिट्रेरी बोल सकते हो ना, अदरवाइज अगर वो प्राइवेट इंस्टीट्यूशन होगा तो आर्टिकल 14 अप्लाई होगा ही नहीं उन पे. इट ओनली अप्लाइज टू स्टेट, राइट? फंडामेंटल राइट्स कैन बी ओनली इन्फोर्स्ड अगेंस्ट द स्टेट. So the Supreme Court laid down the 5-pointer test to decide whether the body can be called as an instrumentality of the state or not. Ab again you can see we have used the term instrumentality of the state. This is the same term that was given by Justice Matthews in the previous case, Sukhdev Singh. Now you know why we call him as crusader of Article 12. he was the one who started this concept of instrumentality of state, and this has been followed till date also, right? So let us look at the 5-pointer test. First, whether the state held the entire share capital of the body or not. Second, whether the state had a deep and persuasive control over that body or not. Third, you have to look whether the financial assistance given by the state is enough to take care of the entire expenditure of that institution or not. Fourth, you have to check whether that body had been granted a monopoly status conferred or preserved by the state. जैसे Indian Railways को monopoly status granted है and it is preserved by the state. This status is preserved by the state. No private company can run railways in India right now. And the fifth condition, whether the body performs a function of public importance or not. If any of these conditions is satisfied by that institution, then that institution would be known as state under Article 12. Next we have Ajay Hasia versus Mujib Sehrawadi. ठीक है, आज इसको हम लोग सीधा अजय हासिया वर्सेस खालिद मुजिब केस भी कहते हैं या अजय हासिया केस भी कहा जाता है. ठीक है, नाउ अभी तक हम इंस्टीट्यूशंस की बात कर रहे थे, अब हम बात करेंगे सोसाइटी की. Now the body in question here was Regional Engineering College in Srinagar, and this was registered as a society under the Jammu and Kashmir Registration of Societies Act of 1898, right? This came now इसको Article 14 के grounds पे इनके कुछ admission पॉलिसीज थी, इनको चैलेंज किया गया था सुप्रीम कोर्ट में, एंड it was contended by the petitioners that those admission policies were arbitrary in nature and therefore violative of Article 14. Principle of arbitrariness क्या है, ये सारी बातें हम Article 14 के वीडियो में करेंगे. ठीक है, so now the first question that the court had to decide was whether it was state or not. That was the first thing. So the court held that this would fall under the ambit of state. So the court held that societies would fall under the ambit of state. और उन्हें किस basis पे किया, अब वो देखो. First, they have given 5 reasons for this decision. First, the composition of the society was dominated by the representatives appointed by the government. Second, the entire finance of the society was taken care of by the government, and the accounts of the society were also under the scrutiny of the government. Third, the rules of the society were also supposed to be made by themselves only, but with the approval of the government. Fourth, the control of the state and central governments was indeed so deep and persuasive that no immovable property of the society could be disposed of without the authority of the government. And fifth, the governments also had the power to appoint any person whom they wanted as a member of the society. Hence, the court held that this society is in the instrumentality of the state, and it can be termed as, therefore it can be termed as state under Article 12. क्लियर? तो अजय हासिया वर्सेस खालिद मुजीब का जो केस है, इसमें भी इन्होंने वही प्रिंसिपल्स इस्तेमाल किए हैं जो आर.डी. शेट्टी वर्सेस इंटरनेशनल एयरपोर्ट अथॉरिटी में यूज़ किया गया था, राइट? लेट अस नाउ मूव ऑन टू सबजीत तिवारी वर्सेस यूनियन ऑफ इंडिया. हियर द इंस्टीट्यूशन इन क्वेश्चन वाज अ काउंसिल, and this is a constitutional bench judgment, that is 5 judges. In this case, the Supreme Court went ahead and said that the Council for Scientific and Industrial Research cannot be termed as state, and the reason they have given is that it does not have a statutory character like ONGC, LIC and IFC, right? So they are following the Rajasthan State Electricity Board वाला principle that अदर अथॉरिटीज़ में सिर्फ वो इंस्टीट्यूशंस आएंगे विच हैव बीन एस्टैब्लिश्ड बाय अ स्टैट्यूट. बट ये सबजीत तिवारी का जो केस है, दिस हैज़ बीन ओवररूल्ड बाय प्रदीप कुमार बिस्वास वर्सेस इंडियन इंस्टीट्यूट ऑफ केमिकल बायोलॉजी. नाउ इफ यू लुक हियर, दिस इज अ 7 judge bench. This is constitutional bench judgment. Always remember that whenever a bench has to overrule its own judgment, a larger bench has to be formed. So for example, if there is a decision of 3-judge bench and it has to be overruled, then it must be overruled by at least a 5-judge bench. 5-judge bench है तो 7-judge bench, 7-judge bench है तो 9-judge bench. अभी तक मैक्सिमम जो हमारी बेंच बैठी है, दैट इज 13-judge bench इन केसवानंद भारती वर्सेस स्टेट ऑफ केरला. राइट. इन दिस केस दिस इज अ 7 जज बेंच, इट इज़ वेरी इंपॉर्टेंट. और यहाँ पे हमने एक ही टेस्ट इस्टेब्लिश किया गया है. एक तो सबजीत तिवारी को ओवररूल किया, स्टैट्यूटरी अथॉरिटी का कोई रिलेशन नहीं है अदर अथॉरिटीज से, इन्होंने पहली चीज़ ये क्लियर की. दूसरी, इन्होंने टेस्ट इस्टेब्लिश किया, इफ अ बॉडी इज फंक्शनली, फाइनेंशियली एंड एडमिनिस्ट्रेटिवली, रिमेंबर फंक्शनली, financially and administratively, right? These are the 3 terms that you have to remember for this case. If a body is functionally, financially, and administratively under the control of the government and the control is pervasive in nature, then that institution would be an instrumentality of the state. Again, if you see, the term instrumentality of the state has been used, which was given by Justice Matthews, right? Next we have Z Telefilms versus Union of India. This is a very famous case. इसमें जो हमारा BCCI है, ये question में आया था that whether it is state or not. So the Supreme Court said that it is not state because of the following 6 reasons. First is the board is not created by a statute. Second, no part of the share capital of the board is held by the government. Third, practically no financial assistance is given by the government to meet the board expenses. Fourth, the board does enjoy monopoly status in terms of cricket, but this has not been conferred by the state. Fifth, there is no existence of deep and pervasive control. And sixth, the board is not created by transfer of a government-owned corporation. It is an autonomous body, right? So again, ये जो सारी चीज़ें हैं, इस पे वही वाला टेस्ट अप्लाई किया गया. फंक्शनली, फाइनेंशियली और एडमिनिस्ट्रेटिवली ये फ्री है गवर्नमेंट कंट्रोल से, राइट? और ये जो 3 टेस्ट है, ये 3 टेस्ट किस पे बेस्ड हैं? ये टेस्ट बेस्ड हैं आर.डी. शेट्टी वर्सेस इंटरनेशनल एयरपोर्ट अथॉरिटी ऑफ इंडिया वाले केस में. ये जो 5 पॉइंटर टेस्ट अप्लाई किए गए थे, इसी को शॉर्टन किया गया है प्रदीप कुमार बिस्वास के केस में, फंक्शनली, फाइनेंशियल और एडमिनिस्ट्रेटिव कंट्रोल में. और इसी को इस्तेमाल किया गया है जी टेलीफिल्म्स वर्सेस यूनियन ऑफ इंडिया में, जहाँ पे BCCI को बोला गया दैट इट इज़ नॉट स्टेट. नेक्स्ट वी हैव अ वेरी लेटेस्ट केस 2023 का है. यहाँ पे कोई भी नया जूरिस्प्रूडेंस इस्टेब्लिश नहीं हुआ है. यहाँ पे सिर्फ हम एक बात करेंगे, देयर इज़ अ इंडियन एसोसिएशन फॉर कल्टिवेशन ऑफ साइंस, ठीक है? ये एक स्टेट ऑफ बंगाल में एक इंस्टीट्यूशन है और वहाँ पे इसको चैलेंज किया गया था. इनका कुछ पॉलिसी इशू आया था, ठीक है? और उसको चैलेंज किया गया कलकत्ता हाई कोर्ट में दैट वेदर इट इज स्टेट और नॉट. तो फर्स्ट क्वेश्चन हमेशा वही आता है, वेदर इट इज स्टेट और नॉट. ओनली देन दे कैन चैलेंज एनी ऑफ द पॉलिसीज मेड बाय दैट इंस्टीट्यूशन, ठीक है? तो व्हाट हैपेंड, the Calcutta High Court said that it is not state. So they filed an appeal to the Supreme Court, and the Supreme Court applied the principles laid down in Pradeep Kumar Biswas and held that IACS, the Indian Association for Cultivation of Science, is state under Article 12. And they have given these 4 reasons for it. IACS is under the administrative control of the Department of Science and Technology under the Ministry of Science and Technology, Government of India. Second, IACS gets nearly 99% of its funds from the Government of India. That is a huge amount, right? And the governing body is also approved by the Government of India. Pervasive control. The general finance rules of the Government of India are required to be followed by IACS. Administrative control, right? And IACS cannot of its own create any post or modify the service conditions of any of its employee without the approval of the Government of India. This is also administrative control. So functionally, administratively and financially तीनों तरीके से कंट्रोल है. Therefore, पूषण मजुमदार वर्सेस यूनियन ऑफ इंडिया 2023 के केस में IACS को स्टेट बोला गया अंडर आर्टिकल 12. This is the end of the video. I know this was a bit longer video than you expected, but Article 12 is a huge topic and fundamental rights के videos छोटे बनाना is kind of a difficult task. Therefore, please expect कि ऐसे 20 to 30 minutes के videos बन सकते हैं. So this is it. This is my Instagram handle. If you want anything, if you want to talk to me, you can DM me at any time, no issues, or you can write to me on my email nilaykumar.lawnet@gmail.com. So I'm gonna see you in the next video. Have a good day.